A very warm welcome to you all on the channel The Noor of Law. The aim behind creating this channel is to help the law students, be it from the law schools or the students preparing for various competitive examinations like judiciary, APO examinations, and also the CBI APP exam, which has recently been notified. So here my goal is to read each and every provision of the Bear Act and explain it to you guys, because what can be seen in today's scenario that the questions in the competitive exams are being equally asked from the areas which were earlier thought to be dry. But now we have to focus upon each and every section of the Bear Act in the class itself. So today I'll be starting with the Prevention of Corruption Act 1988, Part 1, Sections 1 to Section number 16. Let's start with the first slide. So this is the introductory slide, but before that I would like to give you a little background for the Act. The first enactment pertaining to corruption came in the year 1947, which was the Prevention of Corruption Act 1947. But later on it got amended in the year 1952 by the Criminal Law Amendment Act 1952. Again, this act got amended in the year 1964 by the recommendations of Santhanam Committee. But still this act was not found to be that effective. Therefore, the Act of 1988 was introduced, which is the present act which we'll be studying today. What did this 1988 Act do? It widened the scope of public servant. First, even the earlier the provisions that were there in IPC, which were from section number 161 to section number 165A pertaining to the offences with regard to corruption, are now incorporated in this act itself. Then it enhanced the penalties. So basically, it widened the scope, it enhanced the penalties, it incorporated all the offences pertaining to corruption in a one act, which is the Act of 1988. Now let us study the basic essentials that are required to be studied before we study any act. The act number, it is the Act number 49 of 1988. The date of enactment of the act and the date of enforcement are the same. So it is 9th September 1988. Extent is to the whole of India, and even it applies upon the citizens of India who are outside India. Total chapters are 5 in number. Total sections, we have 31 sections in this act. The objective behind this act. The objective behind this act is to consolidate and amend laws relating to prevention of corruption amongst the public servants. Now, this is also a very important keyword that we need to note, that it only covers the public servants and not the private sector. It does not apply on that. Okay. And here the words that are used are consolidate and amend, which shows that this act is what? Exhaustive in nature. Moving on to the next slide. Here I have given you an overview of the 2018 amendment and the impact on Lokpal and Lokayukta Act. So what did this 2018 amendment bring to picture? This is a very substantial amendment which brought very substantial changes. It introduced new offences like section 8, 9, 17A and even redefined the sections 7 and 13. I'll be coming to these sections in the later slides in great detail, but for now I would like you to understand that this 2018 Amendment Act brought two very important aspects, that is the concept of bribe giver and the corporate liability concept. Earlier, in the previous acts, only the bribe taker was punished. But through this act, even the person giving the bribe is being made liable. And here the corporate liability means that even the corporations who are giving bribe are also punished under this act. Okay. It even changed the terminology. Earlier, the term that was used was gratification, which only dealt with money considerations. So the scope was very narrow. But now the term used is undue advantage. Undue advantage can be any form of a favor. So it kind of widened the scope. Plus, it introduced prior approval for investigation under Section 17A. Then, how did the Lokpal and Lokayukta Act amend the Prevention of Corruption Act? The authority, that is the Lokpal, was introduced for sanctioning the prosecution for offences under the Prevention of Corruption Act. Because obviously, we know that in the Prevention of Corruption Act, the offences need to be investigated. So, Lokpal was the authority for the officers like Group A officers or the Group B officers. So, Lokpal was that independent authority who will be investigating these offences against the Group A or the Group B officers. Now, coming to the next slide, Chapter 1 Preliminary. Now, I'll be reading the Bare Act verbatim. So, you have to also open your Bare Act and start underlining along with me. Short title and extent. This act may be called the Prevention of Corruption Act 1988. It extends to the whole of India and it applies also to all the citizens of India outside India. This is a very important point that you need to mark. Then coming to the definitions. Section 2 deals with definitions. Clause A deals with the definition of election. Now, what do you mean by election? Here, the term election is used in a very general sense because it does not refer to any particular form of an election, but it can mean any election by whatever means held under any law for the purpose of selecting members of parliament or of any legislature or local authority or any other public authority. Then coming to clause double A that deals with prescribed means prescribed by the rules made under this act and the expression prescribed shall be construed accordingly. Coming to the next clause, clause B, public duty. What is a public duty and why does a public duty need to be performed? Obviously, we know that a public duty needs to be performed in order to prevent arbitrariness in the society. So it is in the interest of the community at large, the state, the public, that a public duty needs to be performed. So here it is defined as it means a duty in the discharge of which the state, the public, or the community at large has an interest. In this clause, state includes. What does state include? We all know that any corporation, be it established under a central act, provincial act, or a state act, or an authority or a body owned or controlled or aided by the government or a government company as defined in section 617 of the Companies Act 1956. Moving on to the next slide. Clause C deals with the term public servant. What does a public servant mean? Now, many a times in the competitive examination, such questions are asked that which of these is not a public servant or which of these is a public servant. So that is why this becomes important for us. We'll be understanding this with through keywords. I'll be writing a keyword for each of the clauses. Any person in the service or pay of the government or remunerated by the government by fees or commission for the performance of any public duty. तो इसका कीवर्ड क्या हुआ? रेम्यूनरेशन. तो कोई भी पर्सन अगर गवर्नमेंट से रेम्यूनरेशन ड्रॉ कर रहा है, so that person will be a public servant. Then second clause, any person in the service or pay of a local authority. तो second keyword क्या हो गया? Local authority. कोई भी पर्सन अगर किसी लोकल अथॉरिटी से पे ड्रॉ कर रहा है या फिर सर्विस में है किसी लोकल अथॉरिटी की, then that person will also be a public servant. Then coming to the third clause, any person in the service or pay of a corporation established by or under a central, provincial or state act or an authority or body owned or aided by the government or a government company as defined in section 617 of the Companies Act. So third keyword will be under central, state act, etc. Okay. Then Fourth, any judge, including any person empowered by law to discharge, whether by himself or as a member of any body of persons, any adjudicatory functions. So here the fourth keyword is a judge or any person who has been given adjudicatory functions. Adjudicatory functions. Is that clear? So here we need to see that judge also is a public servant, and any person who has been given the adjudicatory duties constitutes to be a public servant. Then fifth, any person authorized by a court of justice to perform any duty in connection with the administration of justice. So then the fifth keyword is administration of justice. So if we'll learn in this way, then it will be easy for us. Any arbitrator or other person to whom any cause or matter has been referred for decision or report by a court of justice. So then the sixth point is arbitrator. Okay. Then seventh, any person who holds an office by virtue of which he is empowered to prepare, publish, maintain or revise an electoral roll. Now any person who is given the duty to conduct elections or prepare the electoral rolls. So seventh key point is election. Eighth, any person who holds an office by virtue of which he is authorized or required to perform any public duty. Any public duty. So eighth is any public duty. Any public duty. Ninth point, any person who is the president, secretary, or other office bearer of a registered cooperative society engaged in agriculture, industry, trade, or banking, receiving or having received any financial aid from the central government, state government, or from any other corporation. Okay. So here the eighth point will be what? Cooperative society. So any corporation established by or under the central, provincial or state act. We have already studied this. Now coming to the 10th point. Any person who is a chairman, member or employee of what? A service commission. For example, UPSC is the exam conducting body, or for example any state PSC which conducts any examination. So a person who is a member of any of these will be what? Public servant. Okay. By whatever name called, or a member of any selection committee appointed by the commission or board for the conduct of any examination or making any selection on behalf of such commission or board. Now 11th point, any person who is a vice chancellor or a member of any governing body, for example if he is a professor, reader, lecturer, so in any way he is related to the university, okay, whose services have been availed of by a university or other public authority, so then that person will also be a public servant. So 11th keyword is university or any public authority. Then coming to the 12th point, any person who is an office bearer or an employee of an educational, scientific, social, cultural or any other institution in whatever manner, receiving or having received financial assistance from whom? Central government or any state government or local or other public authority. So the 12th point will be what? Any institution receiving aid from whom? Central government or state government or local authority or public authority. Okay. Coming to the next definition, which is undue advantage. Now this we already know that has been added by 2018 Amendment Act. Because earlier the term that was used was gratification, which only dealt with money consideration. But through 2018 Amendment Act, the term has been used as undue advantage. Means any gratification whatever other than the legal remuneration. मतलब undue advantage क्या हुआ? कोई unnecessary favor जो एक public servant ले रहा है, ठीक है? कोई भी इस form का gratification जो उसकी legal remuneration से अलग है. For the purposes of this clause, the word gratification is not limited to pecuniary gratifications or to gratifications estimable in money. We have already discussed this point. Then the expression legal remuneration is not restricted to the remuneration paid to a public servant, but it also includes what? Various alliances like house rent allowance, etc. है ना? Which he is permitted by the government or the organization which he serves to receive. Okay. Now there are two explanations, explanation 1 and explanation 2. Explanation 1 says persons falling under any of the above subclauses are public servants, whether appointed by the government or not. Now this is a very key consideration to be noted, because appointment is not the criteria. Appointment is not to be seen. That how a person is appointed is not to be seen. What has to be seen is the earlier clauses that we have already read. If a person falls in that clauses, then that person is a public servant. Explanation 2. Wherever the words public servant occur, they shall be understood of every person who is in actual possession of the situation of a public servant, whatever legal defect there may be in his right to hold that situation. Now, why do you think this explanation 2 has been added in this act? It was added because क्या हो रहा था कि जब किसी पब्लिक सर्वेंट पे करप्शन के चार्जेस लगाए जाते थे, देन दैट पब्लिक सर्वेंट यूज्ड टू कंटेंट कि मेरा तो अपॉइंटमेंट ही सही तरीके से नहीं हुआ है, या मेरा तो अपॉइंटमेंट ही डिफेक्टिव है, तो हाउ कैन यू प्रोसिक्यूट मी? तो उसका मिस यूज रोकने के लिए ये कहा गया इस एक्सप्लेनेशन के थ्रू कि इट डज नॉट मैटर कि आपका अपॉइंटमेंट में कौन सा लीगल डिफेक्ट था. What matters is that you are enjoying that position. You are in the actual possession of that situation of a public servant is what is necessary. Okay. Now coming to the chapter 2, appointment of special judges. Section 3 deals with power to appoint special judges. Now in the Prevention of Corruption Act, the cases are tried or the cognizance is taken by whom? The special judges. The central government or the state government may, by notification in the official gazette, appoint as many special judges as may be necessary for such area or areas or for such case or group of cases as may be specified in the notification to try the following offences. Now, what form of offences will be tried? Clause A says any offence which is punishable under this particular act, plus clause B says any conspiracy, any attempt or any abetment to commit that particular offence which is mentioned under clause A. Clause 2 says a person shall not be qualified for appointment as a special judge. Now here the qualifications of a special judge are given, that that person needs to be what? He is or has been a sessions judge, additional sessions judge, or an assistant session judge under the CRPC. Now we all know that under the BNSS, the post of assistant session judge has been removed. So that you have to keep in mind. Okay. Section 4, cases triable by special judges. Clause 1, notwithstanding anything contained in the CRPC or in any other law for the time being in force, the offences specified in subsection 1 of section 3 shall be tried by the special judges only. Here the use of the word shall and only clearly specifies that only the special judges are given what? The exclusive jurisdiction to try such cases under this act. Okay. Every offence specified in subsection 1 of section 3 shall be tried by the special judge for the area within which it was committed, or as the case may be by the special judge appointed for the case, या फिर जहां पे एक या एक से अधिक जजेस हैं, मतलब दो या दो से अधिक जजेस हैं, तो वहां पे कौन डिसाइड करेगा कि कौन सा जज जो है वो ट्राई करेगा उस केस को? सेंट्रल गवर्नमेंट विल बी द डिसाइडिंग अथॉरिटी. Okay. Now coming to the next point, when trying any case, a special judge may also try any offence other than the offence specified in section 3 with which the accused may be charged under the CRPC. अब अगर section 3 का offence already बन रहा था उस accused पे, plus he was charged with any other offence, then that person will be charged under the same trial. Now coming to the clause number 4, notwithstanding anything contained in the CRPC, ये जो ट्रायल है वो कैसे होगा, ऑन डे टू डे बेसिस. दिस क्लॉज वाज आल्सो एडेड बाय द 2018 अमेंडमेंट एक्ट. एंड यहाँ पे टाइम पीरियड बहुत इंपॉर्टेंट है कि आपको जो ट्रायल है वो खत्म कितने टाइम पीरियड में करना है, 2 years में. प्लस अगर वो एक्सीड होता है तो उसके रीजंस रिकॉर्ड किए जाएंगे जहां पे ये ट्रायल कंक्लूड नहीं होता है 2 years के अंदर. एंड इट कैन बी एक्सीडेड बाय व्हाट टाइम, 6 months at a time. And in any case, it cannot exceed what time? 4 years in aggregate. This you have to see. Okay. Section 5, procedure and powers of special judge. Now, a special judge may take cognizance of offences without the accused being committed to him. Now, this is an exception to the earlier CRPC and the today's BNSS. Because in the earlier CRPC, in section 209, it was mentioned that session judge can only try the offences that are committed for the trial. But here, even without committal, the special judge can take cognizance of offences. Trying the accused person shall follow the procedure prescribed by the CRPC for the trial of warrant cases by magistrate. This is also a very important point that you need to note down. That here the method will be followed is the trial of warrant cases by magistrates. A special judge may, with a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offence, even can tender a pardon, which was earlier done under 308 or 307 of CRPC, can now also be done under the Prevention of Corruption Act on condition of his making a full and true disclosure of the whole circumstances within his knowledge. गवर्नमेंट विटनेस बना लिया जाता है ना उस पर्सन को कि आप सारी चीजें डिस्क्लोज कर दो, सारे सर्कमस्टेंसेस डिस्क्लोज कर दो, एंड यू विल बी गिवन अ पार्डन relating to the offence and to every other person concerned, whether he is concerned as a principal or an abettor in the commission thereof, and any pardon so tendered shall, for the purposes of subsections 1 to 5 of section 308 of CRPC, to be deemed to have been tendered under section 307 of that code. Let me tell you the BNSS section for the same as well. So in BNSS, the section is section 345. BNSS. Okay. Coming on to the next slide. Save as provided in subsection 1 or subsection 2, the provisions of CRPC shall, so far as they are not inconsistent with the Act, apply to the proceedings before the special judge, and for the purposes of the said provisions, the court of special judge shall be deemed to be what? A court of session, and the person prosecuting will be deemed to be the public prosecutor. The court will be deemed to be of the court of session and the person prosecuting the public prosecutor. In particular, and without prejudice to the generality of the provisions contained in subsection 3, the provisions of section 326 and 475 of CRPC. Now, what is 326? It says the evidence partly recorded by one judge and partly by another. Okay. So it basically says that the previous testimony will not be going into vain, and that the next judge that is coming in his place will be starting the case from that very point. Similarly, this has been done in the Prevention of Corruption Act, that if any other judge comes into place, then the case can be started from that very point. And even in the case of transfer of cases as well. Then coming to section 475, it deals with the situation where the accused person is found to be under the military law or the army law or the navy law for that matter. So then that person can be transferred to the commanding officer of that very authority. Okay. But now in BNSS, these sections are, let me tell you that as well. The sections are 365 and 521. 365 and 521 of BNSS. in place of 326 and 475 of CRPC. A special judge may pass upon any person convicted by him any sentence authorized by law for the punishment of the offence of which such person is convicted. A special judge, while trying an offence punishable under this act, shall exercise what powers? That the powers that are exercisable by district judge under the Criminal Law Amendment Ordinance 1944. Same powers will be exercised by the special judge here. Section 6, power to try summarily. Now, summary trial will be done only for specific cases. The cases relating to Section 12A of the Essential Commodities Act or in Clause A of that subsection. So, wherever a special judge tries any offence, normally we know that the procedure that is followed is warrant cases, method of warrant cases. But if there is such a case, an offence has been committed in subsection 1 of section 3, which is related to what? The contravention of any special order referred to in subsection 1 of section 12A of the Essential Commodities Act or of an order referred to in clause A of that subsection, then the special judge has the power to try that offence in a summary manner. Then notwithstanding anything contained, okay, notwithstanding anything contained, because earlier the procedure was given in the section 5. So now we are not obeying that procedure or section 260 of the CRPC. The special judge shall try the offence in a summary way. In the BNSS, the section is section 283. Provided that in case of any conviction in a summary trial under this section, it shall be lawful for the special judge to pass a sentence of imprisonment for a term not exceeding 1 year. This is also very important, that when the special judge will try the offence summarily, what punishment can he give? Up to 1 year. Provided further that when at the commencement of or in the course of summary trial under this section, it appears to the special judge that the nature of the case is such that a sentence of imprisonment for a term exceeding 1 year needs to be passed. अब अगर वो जज को लगता है, स्पेशल जज को, कि 1 साल से अधिक की पनिशमेंट यहाँ पे जरूरी है, then the special judge shall, after hearing the parties, record an order to that effect. मतलब reasons देगा वो judge, and thereafter recall any witnesses who may have been examined and proceed to hear or rehear the case in accordance with the procedure prescribed by the said code, which was trial of warrant cases by magistrate. Then that normal procedure which was being earlier followed for the other offences, तो वही follow किया जाएगा by the special judge. Notwithstanding anything to the contrary contained in this act or in the CRPC, there shall be no appeal, but only where the punishment does not exceed 1 month. This is a very important point that you need to note. कि अपील कहाँ पे रेस्ट्रिक्ट की गई है? by a convicted person in case tried summarily under this section in which the special judge passes an imprisonment of not exceeding 1 month. क्योंकि नॉर्मली उसकी पार है, ही कैन पास सेंटेंस अप टिल 1 ईयर. ठीक है, तो बाकी सारे केसेस में अपील इज नॉट बीइंग रेस्ट्रिक्टेड. Only in this scenario where he passes a sentence which does not exceed 1 month, there the appeal is barred. And a fine not exceeding 2000 rupees. यहाँ पे भी appeal barred है. Whether or not any order under section 452 of the said code is made in addition or not. But an appeal shall lie where any sentence in excess of the aforesaid limits is passed by the special judge. Obviously, अगर 1 month से ज़्यादा है ना, 1 month से ज़्यादा है, then appeal can be made. Chapter 3, Offences and Penalties. Section 7. Now, Section 7 deals with the offence relating to public servant being bribed. Now, here the public servant is being bribed. Bribe taker is punished under Section 7. Okay. Any public servant who obtains or accepts or attempts to obtain from any person an undue advantage with the intention to perform or cause performance of public duty improperly. अब वो क्या बोल रहा है, वो क्यों एक्सेप्ट कर रहा है वो ब्राइब, या फिर अटेम्प्ट कर रहा है उसको ऑब्टेन करने के लिए, कि वो अपनी ड्यूटी किस तरीके से परफॉर्म करेगा, या तो वो इम्प्रॉपरली परफॉर्म करेगा, या फिर वो डिसऑनेस्टली अपनी ड्यूटी करेगा, या फिर वो अपनी ड्यूटी ही नहीं करेगा खुद, या फिर किसी और से बोलेगा कि अपनी ड्यूटी मत करो. सच ड्यूटी ईदर बाय हिमसेल्फ और बाय अनदर पब्लिक सर्वेंट, और परफॉर्म्स और इंड्यूसेस अनदर पब्लिक सर्वेंट, या वो किसी और पब्लिक सर्वेंट को इंड्यूस कर रहा है टू परफॉर्म हिज ड्यूटी इम्प्रॉपरली, डिसऑनेस्टली, या फिर मत करो परफॉर्म, उसको ये बोल रहा है, इन एंटिसिपेशन ऑफ व्हाट, और इन कॉन्सिक्वेंस ऑफ व्हाट, accepting an undue advantage from any person, shall be punished with which imprisonment, not less than 3 years, which may extend to 7 years, and shall also be liable to fine. Not less than 3 years, extends to 7 years, and fine. Okay. Now there is this set of explanations that have been given. Explanation 1. For the purpose of this section, the obtaining, the accepting, or the attempting to obtain an undue advantage shall itself constitute an offence, even if the performance of duty by the public servant is not or has not been improper. अब वो ये डिफेंस ले ले कल को पब्लिक सर्वेंट कि मैंने अपनी ड्यूटी इम्प्रॉपरली तो परफॉर्म की ही नहीं, मेरी तो जो ड्यूटी बनती थी मैंने वही परफॉर्म की और उसी तरीके से परफॉर्म की, बट भाई आपने पैसे लिए ना उसके लिए, आपने कुछ रुपीस, कुछ सम, या फिर कुछ फॉर्म ऑफ अनड्यू एडवांटेज लिया उसके लिए, स्टिल यू आर लायबल. तो इसका मिस यूज ना हो जाए प्रोविजन का, दैट इज व्हाई दिस एक्सप्लेनेशन 1 वाज एडेड. आई विल एक्सप्लेन इट टू यू थ्रू दिस इलस्ट्रेशन. A public servant S asks a person P to give him an amount of 5,000 rupees to process his routine ration card application on time. अब वो ड्यूटी तो प्रॉपर ही कर रहा है, but he is charging what? 5,000 rupees. So S is still guilty of an offense under this section. Explanation 2. For the purposes of this section, the expression obtains or accepts or attempts to obtain shall cover cases where a person being a public servant obtains or accepts or attempts to obtain any undue advantage for himself or for another person. So that does not matter कि जो वो undue advantage ले रहा है वो खुद के लिए ले रहा है या किसी अपने related person के लिए ले रहा है. But the main thing is that he is abusing his position as a public servant, or by using his personal influence over another public servant, or by any other corrupt या फिर illegal means. It shall be immaterial whether such person being a public servant obtains, accepts or attempts to obtain the undue advantage, या वो directly ले रहा है, through a third party ले रहा है, that does not matter. The thing that matters is that he is taking that undue advantage or is attempting to take that undue advantage. Okay, now coming to the next offense, that is section 7A, taking undue advantage to influence public servant by corrupt or illegal means or by the exercise of personal influence. Now I have shown you this diagram which explains this scenario clearly. Here the middleman is being punished. क्योंकि section 7 में क्या था ना, जो person actually bribe ले रहा था, that person was being punished क्योंकि public servant खुद से bribe ले रहा था under section 7. बट अंडर सेक्शन 7A एक मिडलमैन आ जाता है और मिडलमैन प्रॉमिस करता है कि आई विल बी इन्फ्लुएंसिंग द पब्लिक सर्वेंट, आप मुझे कोई अनड्यू एडवांटेज दे दो, क्लाइंट से या फिर सिटीजन से किसी से बोलता है कि आप मुझे अनड्यू एडवांटेज दे दो एंड मैं आपका काम करवा दूंगा किससे, पब्लिक सर्वेंट से. तो हियर इन सेक्शन 7A दैट मिडलमैन इज बीइंग पनिश्ड. Whoever accepts or obtains or attempts to obtain from another person for himself और for any other person any undue advantage as a motive. अब चाहे वो खुद के लिए वो undue advantage ले, चाहे वो अपने किसी relative के लिए ले, but he is taking that undue advantage to induce a public servant. This is very important. By corrupt or illegal means or by exercise of his personal influence to perform or to cause performance of a public duty improperly या dishonestly या फिर उसको forbear कर रहा है to perform such duty, or by another public servant shall be punishable with what imprisonment? Again, the same imprisonment, not less than 3 years, but which may extend to 7 years and shall also be liable to fine. Is that clear? Now coming to section 8. Section 8 deals with direct bribe giving. Now this is the offense that has been introduced by the amendment of 2018. Here the bribe giver is also being made liable. कि अगर कोई पर्सन ब्राइब दे रहा है टू एनी पब्लिक सर्वेंट कि उसका कोई काम हो जाए, so that person is also being made liable under the section 8 of this act. Any person who gives or promises to give an undue advantage to another person or persons with the intention to induce a public servant to perform improperly या फिर किसी form of reward के लिए कि आप reward कर रहे हो उस public servant को कि उसने improper performance किया of public duty जिससे आपको फायदा हुआ, ठीक है. So then that will be punishable with imprisonment for a term which may extend to 7 years or with fine or with both. Now यहाँ पे imprisonment कितने साल का हो सकता है? 7 years और fine और both. जो ब्राइब टेकर था और जो ब्राइब ले रहा था, जो मिडलमैन अंडर सेक्शन 7 एंड सेक्शन 7A, उस केस में पनिशमेंट वाज मिनिमम 3 years and was extending to 7 years plus fine. But यहाँ पे the imprisonment can extend up to 7 years or fine or both. Okay. Provided that the provisions of this section shall not apply where a person is compelled to give such undue advantage. अब अगर किसी पर्सन को कंपेल किया जा रहा है कि उसको मजबूरी में वो undue advantage देना पड़ रहा है, so then that person will not be charged under this section. पर उसको अपना गुड फेथ दिखाने के लिए क्या प्रूफ करना पड़ेगा? ही शैल रिपोर्ट द मैटर टू द लॉ एनफोर्समेंट अथॉरिटी or the investigating agency within a period of 7 days from the date of giving such undue advantage. This is also a very important point that you need to note down. Provided कि अगर उसने रिपोर्ट कर दिया मैटर, सब कुछ कर दिया, बट हेल्प करने के लिए टू दैट एनफोर्समेंट एजेंसी या इन्वेस्टिगेशन एजेंसी की हेल्प करने के लिए अगर उसने वो अनड्यू एडवांटेज दे दिया, तो उसको लायबल नहीं किया जाएगा अंडर सेक्शन 8, क्योंकि उसने रिपोर्ट भी कर दिया मैटर एंड जस्ट टू हेल्प द इन्वेस्टिगेटिंग एजेंसी टू रीच अप टू द क्रिमिनल, तो फिर उसको लायबल नहीं किया जाएगा अंडर सेक्शन 8. अब इसमें कमर्शियल ऑर्गेनाइजेशन के लिए भी बोला गया है कि कमर्शियल ऑर्गेनाइजेशन भी अगर ब्राइब देता है तो दैट इज ऑल्सो पनिशेबल. अ पर्सन पी गिव्स अ पब्लिक सर्वेंट एस एन अमाउंट ऑफ 10,000 rupees to ensure that he is granted a license over all the other bidders, so obviously he is guilty of such offense क्योंकि वो दे रहा है bribe. Bribe giver is punished under section 8. So this is the explanation that I have already explained कि it shall be immaterial कि whether the person to whom an undue advantage is given or promised to be given is the same person as the person who is to perform. So that does not matter कि जिसको आप undue advantage दे रहे हो whether वही person आपको वो benefit avail करवाएगा या फिर कोई और person करवाएगा, है ना. And nothing in subsection 1 shall apply to a person if that person after informing the law enforcement authority, this we have already discussed कि अगर वो person after informing the investigation agency अगर वो still promises to give या फिर gives an undue advantage to another person in order to assist such lawful enforcement authority, then that person will not be charged under this act or under this section 8. Now coming to section 9. ये भी कॉन्सेप्ट 2018 अमेंडमेंट एक्ट के थ्रू इंट्रोड्यूस किया गया था, ब्राइबिंग बाय अ कमर्शियल ऑर्गेनाइजेशन. अगर कोई कमर्शियल ऑर्गेनाइजेशन किसी बिजनेस में फायदे के लिए या फिर कंडक्ट ऑफ द बिजनेस के रिलेशन में कुछ करवाने, कोई काम करवाने के लिए, कोई फेवर लेने के लिए अगर दे रहा है या प्रॉमिस कर रहा है पब्लिक सर्वेंट को कोई भी रेम्यूनरेशन या फिर अनड्यू एडवांटेज, देन दैट इज आल्सो पनिशेबल अंडर सेक्शन 9. Coming to the verbatim section 9, where an offence under this act has been committed by a commercial organization, such organization shall be punishable with fine if any person associated with such commercial organization gives or promises to give any undue advantage to a public servant. किस चीज के लिए दे रहे हैं वो ब्राइब? To obtain or retain business for such commercial organization या फिर to obtain or retain an advantage in the conduct of business for such commercial organization. provided that it shall be a defense for the commercial organization. क्या defense लेगा commercial organization कि हमने proper guidelines जो थी उसका compliance किया है, to prove that it had in place adequate procedures in compliance of such guidelines as may be prescribed to prevent persons associated with it from undertaking such conduct. कि हमारी organization में वो जो adequate procedures हैं उनका compliance किया गया है guidelines का. So this is the only available defense for a commercial organization. Otherwise, that commercial organization will be held to be liable. For the purposes of this section, a person is said to give or promise to give any undue advantage to a public servant if he is alleged to have committed the offence under section 8, whether or not such person has been prosecuted for such offence. तो similarly जो essentials थे section 8 में वही same चीज apply हो रही है यहाँ पे commercial organization के case पे, because in section 8 bribe giving was being punished. Okay. For the purposes of section 8 and this section, what is a commercial organization? A body which is incorporated in India and which carries on business whether in India or outside India, या तो वो incorporated हो India में, ठीक है, या फिर any other body which is incorporated outside India but carries on its business in the part of India, ठीक है, या तो वो incorporated हो India में and carries on business abroad, या फिर it is incorporated abroad but carries on business within India. Similarly, in case of partnership firm या फिर association of persons, या तो formed हो India में and carries on business within India or outside India. Otherwise, a partnership or association of persons which is formed outside India but carries on business in the part of India or in any part of business within India. Business. B clause deals with business, includes a trade or profession or providing service. Okay, it can be any trade, any profession, or any form of a service that is being provided that will constitute to be business. Then C clause deals with a person is said to be associated with a commercial organization if such person performs services for or on behalf of the commercial organization. अगर कोई person कोई services दे रहा है in relation to a particular commercial organization, तो हम बोलेंगे ना कि that person is related to that particular organization, irrespective of any promise to give or giving of any undue advantage which constitutes an offence under subsection 1. ये जरूरी नहीं है कि आपने ही promise किया हो. If you are related to that commercial organization, then you will be held to be liable. Explanation 1. The capacity in which the person performs services for or on behalf of the commercial organization shall not matter irrespective of whether such person is employee or agent या subsidiary. ये depend नहीं matter नहीं करता है कि आप किस relation में हो उस organization के अंदर, whether you are an employee, agent, subsidiary, आपका role does not matter. What matters is that you are related with that organization. Your capacity is that you are performing some services for that organization. That is what makes you related with that commercial organization. Explanation 2. Whether or not the person is a person who performs services for or on the behalf of commercial organization, कौन determine करेगा इस fact को? The relevant circumstances, and not merely by reference to the nature of the relationship between such person and the commercial organization. So overall circumstances will be seen and not the relationship. Explanation 3. If the person is an employee of the commercial organization, it shall be presumed, shall presumption है यहाँ पे कि अगर वो person कोई employee है commercial organization का, तो ये माना जाएगा कि such person is a person who has performed services for or on behalf of the commercial organization. Notwithstanding anything contained in CRPC, the offences under 7A, 8 and this section shall be cognizable. These offences are made cognizable. The central government, तो मतलब इन offences के लिए the accused can be arrested without warrant. Okay. The central government shall, in consultation with the concerned stakeholders, including departments, and with a view to preventing persons associated with commercial organizations, क्या कर सकता है state central government? ये सब प्रिवेंट करने के लिए फ्रॉम ब्राइबिंग एनी पर्सन बीइंग अ पब्लिक सर्वेंट कुछ गाइडलाइंस प्रिस्क्राइब की जा सकती हैं बाय द सेंट्रल गवर्नमेंट एज वे बी कंसिडर्ड नेसेसरी, जो कि पुट इन प्लेस की जा सकती हैं बाय दैट पर्टिकुलर कमर्शियल ऑर्गेनाइजेशन इन ऑर्डर टू प्रूव द डिफेंस। ठीक है। सेक्शन 10, पर्सन इन चार्ज ऑफ कमर्शियल ऑर्गेनाइजेशन टू बी गिल्टी ऑफ द ऑफेंस। अब जब कमर्शियल ऑर्गेनाइजेशन को चार्ज किया गया फॉर ब्राइब गिविंग, तो who will be made liable? Where an offense under Section 9 is committed by a commercial organization and such offense is proved in the court to have been committed with the consent or connivance of any director. यहाँ पे consent या फिर connivance is very important. डायरेक्टर का, मैनेजर का, सेक्रेटरी का और अदर ऑफिसर का, देन शैल बी ऑफ अ कमर्शियल ऑर्गेनाइजेशन, सच डायरेक्टर, मैनेजर, सेक्रेटरी और अदर ऑफिसर शैल बी गिल्टी ऑफ द ऑफेंस and shall be liable to be proceeded against and shall be punishable with imprisonment for a term which shall not be less than 3 years but which may extend to 7 years and shall also be liable to fine. For the purposes of this section, director in relation to a firm means a partner in the firm. So director means what? Partner in the firm. जो हमने ऑफेंसेस देखे थे सेक्शन 7 में और 7A में, वहां पे भी इम्प्रिजनमेंट 3 years मिनिमम एंड 7 years प्लस फाइन था। सिर्फ सेक्शन 8 में द इम्प्रिजनमेंट वाज अप टू 7 years और फाइन और बोथ एंड यहाँ पे भी कमर्शियल ऑर्गेनाइजेशन के केस में भी द पनिशमेंट इज 3 years बट विच मे एक्सटेंड टू 7 years एंड शैल ऑल्सो बी लायबल टू फाइन। ओके। Section 11, public servant obtaining undue advantage without consideration from person concerned in proceeding or business transacted by such person, public servant। अब ये किस सिनेरियो को शो करता है? अब सपोज एक ऑडिट होना है शॉप का, जो टैक्सिंग ऑफिसर है उसने उस शॉप का ऑडिट अप्रूव कर दिया एंड इन रिटर्न ऑफ दैट जो पर्सन है, शॉप का ओनर है, ही इज ऑफरिंग फ्री वाउचर्स एवरी मंथ, फ्री वाउचर्स एवरी मंथ टू द शॉपकीपर, टू द टैक्सिंग ऑफिसर। What is this now? This is made chargeable under Section 11. This scenario itself, whoever being a public servant accepts or obtains or attempts to obtain for himself or for any other person any undue advantage without consideration or for a consideration which he knows to be inadequate। अगर उसको पता है कि कोई चीज का इतना प्राइस है एंड स्टिल ही इज गेटिंग दैट फॉर अ वेरी माइन्यूट अमाउंट, so that shows कि ये consideration is very inadequate and something fishy is going on from any person whom he knows to have been or to be likely to be concerned in the proceeding or business transacted or about to be transacted। जैसे कि यहाँ पे जो टैक्सिंग ऑफिसर है ऑलरेडी उसने उस शॉप का ऑडिट अप्रूव किया था and now afterwards that person is receiving some sort of benefit from the shop owner without any consideration being given by the taxing officer। So what did that show? This exactly is the scenario that is covered by Section 11. With the official functions of the public duty of himself or of a public servant to whom he is subordinate or from any person whom he knows to be entrusted in or related to the person so concerned, then कितना imprisonment इस केस में होगा? Not less than 6 months but which may extend to 5 years and shall also be liable to fine। Now coming to the next section, section number 12, punishment for abetment of offences। Whoever abets any offence punishable under this act, whether or not that offence is committed। Now that is not the determining factor कि offence हुआ या नहीं, आपने abet किया, that is the main ingredient। In consequence of that abetment shall be punishable with imprisonment for a term which shall not be less than 3 years but which may extend to 7 years and shall also be liable to fine। Section number 13, criminal misconduct by a public servant। Here we will also be studying the concept of disproportionate assets। A public servant is said to commit the offense of criminal misconduct if he dishonestly, fraudulently, misappropriates or otherwise converts for his own use any property entrusted to him. अब गुड फेथ में कोई प्रॉपर्टी उसको एंट्रस्ट कर दी गई थी, बट पब्लिक सर्वेंट ने क्या किया, उसको कन्वर्ट कर लिया टू हिज ओन यूज. ठीक है, सो देन दैट will be termed as a criminal misconduct by a public servant. या फिर he intentionally enriches himself illicitly during the period of his office. जो उसका लीगल रेम्यूनरेशन है उसके अलावा उसने खुद को illicitly enrich किया. Explanation 1. A person shall be presumed to have intentionally enriched himself illicitly if he or any person on his behalf is in possession of or has at any time during the period of his office been in possession of pecuniary resources or property disproportionate to his known sources of income. Here comes the concept of disproportionate assets. अब अगर किसी पब्लिक सर्वेंट के पास ऐसा कोई इनकम है या ऐसे कोई एसेट्स हैं जिसकी वो सोर्स लोकेट नहीं कर पा रहा है या फिर दिखा नहीं पा रहा है उसकी सोर्सेस, ठीक है, so then that will constitute to be what? Disproportionate assets which the public servant cannot satisfactorily account for. Explanation 2. The expression known sources of income means income received from any lawful sources. या तो वो दिखा दे कि इस lawful source से मेरे पास ये income आई है या फिर मेरे पास ये undue any advantage आया है. But अगर ये पाया गया कि that person is not able to locate the sources of income for the same, then that will be held to be disproportionate assets and that person will be charged with criminal misconduct. A public servant who commits criminal misconduct shall be punishable with imprisonment for a term which shall not be less than 4 years but which may extend to 10 years and shall also be liable to fine. Minimum 4 years, extend to 10 years plus fine. ये आपको ध्यान में रखना है. Section 14. These are the last 3 sections. तो buckle up. अब हमें इसके बाद थोड़े से केस लॉज हम लोग देखेंगे क्योंकि केस लॉज आर ऑल्सो वेरी इंपॉर्टेंट फॉर द बेसिक अंडरस्टैंडिंग ऑफ द प्रिवेंशन ऑफ करप्शन एक्ट. सेक्शन 14 पनिशमेंट फॉर हैबिचुअल ऑफेंडर. अब अगर कोई पर्सन पहले भी चार्ज था अंडर दिस एक्ट एंड सब्सिक्वेंटली अगेन कमिट्स एन ऑफेंस पनिशेबल अंडर दिस एक्ट shall be punishable with imprisonment for a term which shall not be less than 5 years but which may extend to 10 years and shall also be liable to fine. 5 years minimum to 10 years plus fine. Okay. Now section number 15, punishment for attempt. Whoever attempts to commit an offence referred to in clause A of subsection 1 of section 13. हमने section 13 में क्या देखा? Criminal misconduct देखा. तो उसी के अंदर अगर कोई पर्सन अटेम्प्ट कर रहा है उस ऑफेंस को करने का, देन शैल बी पनिशेबल विद इम्प्रिजनमेंट फॉर अ टर्म व्हिच शैल नॉट बी लेस देन 2 years बट व्हिच मे एक्सटेंड टू 5 years एंड विद फाइन. 5 years plus fine. Matters to be taken into consideration for fixing fine. अब जो हमने देखा कि सेक्शन 7 के अंदर, 8 के अंदर, 9 के अंदर, 10, 11, 13 क्लॉज 2, 14, 15 सब में हम लोग प्लस फाइन या और फाइन पनिशमेंट दे रहे हैं, है ना. तो ये फाइन का क्या होगा डिटरमाइनिंग फैक्टर कि कितना फाइन चार्ज करना है. तो हम क्या कंसिडरेशन में लिया जाएगा बाय द स्पेशल जज. He will take into consideration the amount or the value of the property which the accused person has obtained by committing the offense. किस लेवल की कितने प्राइस की वो जो प्रॉपर्टी है उसने उसकी हेराफेरी की है. और where the conviction is for an offense referred to in clause B of section 13 subsection 1 जो कि था क्रिमिनल मिसकंडक्ट के रिलेटेड, then the pecuniary resources या फिर property referred to in that case for which the accused person is unable to account satisfactorily. जो नोन सोर्सेज ऑफ इनकम थे वो नहीं बता पा रहा था ना, वो कितने प्राइस की इनकम के लिए नहीं बता पा रहा था. इसके अलावा कौन सी जो कितने प्राइस ऑफ मनी के लिए he was not able to account for. Now coming to the relevant case laws. तो सबसे पहले हम लोग केस लॉज देख रहे हैं सेक्शन 7 और सेक्शन 20 के रिलेशन में. नीरज दत्ता वर्सेस स्टेट एनसीटी ऑफ दिल्ली. सेक्शन 20 आई विल बी कवरिंग इन द नेक्स्ट पार्ट ऑफ द वीडियो. ठीक है. प्रूफ ऑफ डिमांड इज अ सिना क्वा नॉन. यहाँ पे क्या बोला गया कि आप किसी पर्सन को प्रोसिक्यूट करने से पहले, किसी पब्लिक सर्वेंट को प्रोसिक्यूट करने से पहले ये देखोगे कि वहां पे एक डिमांड होनी चाहिए फॉर अनड्यू एडवांटेज. ठीक है. So it was held that a prior demand for undue advantage by the public servant is a sine qua non, that is the essential requirement for conviction under section 7, and that was the earlier section 13 clause 1 subclause D. Mere recovery of tainted money is not sufficient. Demand can be proved through circumstantial evidence if the complainant is unavailable. So the demand can also be proved through what? Circumstantial evidence के थ्रू आप प्रूव कर दो अगर कंप्लेनेंट नहीं है वहां पे तो. But demand should be proved. Then coming to the next case law, again the P Satyanarayan Murthy versus State of Andhra Pradesh. यहाँ पे भी same requirement को reiterate किया गया था. Reaffirmed that the prosecution must prove both the demand for the illegal gratification and its acceptance by the accused. ठीक है. एंड इन द एब्सेंस ऑफ प्राइमरी एविडेंस आप कैसे प्रूव कर सकते हो? बाय द सर्कमस्टेंशियल एविडेंस. ठीक है. बट मियर रिकवरी के बेसिस पे या फिर प्रिजम्पशन के बेसिस पे यू कैन नॉट जस्टिफाई द conviction of that accused. Section 2C that deals with the definition of public servant. तो पीवी नरसिम्हा राव वर्सेस स्टेट सीबीआई के केस में ये बोला गया था कि MPs are also public servants. A constitution bench held that members of parliament and the members of legislative assemblies are considered public servants under the Prevention of Corruption Act, so making them liable for prosecution under this act for corruption. Okay. Then coming to section 13 clause 1 subclause E, disproportionate assets. State of Tamil Nadu versus R Soundri Rarasu. बर्डन ऑफ प्रूफ इन डिस्प्रपोर्शनेट एसेट केसेस किस पे होगा? तो सबसे पहले बर्डन ऑफ प्रूफ होगा ऑन प्रोसिक्यूशन टू प्रूव कि उस पर्सन के पास या फिर उस पब्लिक सर्वेंट के पास कुछ ऐसे एसेट्स हैं जो कि डिस्प्रपोर्शनेट हैं, जो कि वो लोकेट नहीं कर पा रहा है. एंड वंस दिस इज डन देन द burden shifts to the accused to provide a satisfactory explanation for the disproportionate assets. Then this case law I'll be dealing with in the next video relating to the section number 17 to section 31 of the Prevention of Corruption Act. For now I'll be doing this. Section 2 clause C. State of Gujarat versus Mansukh Bhai Kanjibai Shah 2020 case of Supreme Court. Here the broad scope was laid down for public duty. Public duty क्या होता है? इसके scope को बहुत broaden किया गया था. It expanded the definition of public servant to include even the officials of a deemed university. And it affirmed that any person performing a public duty where the community at large is having an interest falls under the Prevention of Corruption Act's ambit. Okay. Then section 9 और section 8 के reference में हमने already देखा कि कैसे जो ये 2018 का अमेंडमेंट एक्ट है that brought into picture the concept of corporate liability and section 8 the concept of Bribegiver. So therefore we come to the end of the video and here are the key takeaways. We studied today how the Prevention of Corruption Act consolidates anti-corruption laws in India. We also studied the 2018 Amendment Act, the two important concepts that it brought in. Lokpal Act also we refer to how the Lokpal helps in investigation of cases of Group A or Group B servants, officers. Okay. And now we know that both these acts, be it Lokpal Act and the Prevention of Corruption Act, they operate in harmony to combat the corruption effectively. Now, as we come to the end of the video, if you guys have any doubt with respect to any concept that I have explained today or with respect to any section that we have dealt with in today's lecture, you guys can ping me in the comment section below. And if you need the PPT that I have already displayed in this video, then you can also tell me that in the comment section below and I'll be providing you with the link in the next video for the same. The complete PPT I'll be giving you in the next video if you tell me to do that in the comment section below. And do like and subscribe to my channel if you think that you really it helped you in a way.